One more. Okay, you have a break. Morning, Your Honor.
Or afternoon, I'm sorry.
Afternoon. Yeah.
This is a matter of the guardianship of Garrett Dosch, 99G0200357. Counsel, your appearance for the record.
Good afternoon, Dara Goldsmith, file number 4270, along with my clients Travis and Melodie Dosch. Good afternoon, Your Honor. Elizabeth Brickfield, 6236. I'm the guardian ad litem in this matter.
Good morning, Your Honor. Afternoon, Your Honor. James Berchtold, Legal Aid Center of Southern Nevada, bar number 5874, here for Garrett Dosch, and Garrett is with me today as well.
Hi, Garrett. How are you? It's good to see you. Thanks for being here.
Lynn Hughes, part number 6849, on behalf of Garrett Dosch, she was also present.
Thank you, Mr. Hughes. Everybody have a seat. Garrett, I think there's a chair for you over there. You can sit, or if you feel more comfortable standing, please make yourself at home. Counsel, I saw that just as a point to save time, let me raise this initially. The first amended accounting was filed on January 6th. It is over 200 pages long. The compliance division of the Judicial District Court notified my department that due to the length and the time issue, they didn't have sufficient time to review it. I do not feel comfortable going forward with the accounting issues until the compliance division of the court has an opportunity to review the accounting. Now, that being said, I know that there's already been an objection that was filed to that. I see that it's a short objection, and I'm gonna guess that was because of the time constraint. So if anybody has, I would like to continue those accounting issues. Does anybody have, because I wanna give compliance an opportunity to review them. Does anybody have any objections or concerns with that? Well, I mean, I know, it's been going on too long. No, and I know that's not what you're gonna say. Let me say, it has been going on too long. I don't wanna move it.
So, Your Honor, when we were here last August, you ordered us to do a meet and confer, and then gave us 30 days from the filing date to have the meet and confer within that time. We have agreed on a date, which is the 28th at 2 p.m.
January 28th?
January 28th, where we will sit down and do the meet and confer. You did order that we then file any objections within that same 30-day period. We might need a little more time because the meeting is so close to the end of the period, so I might need just a little more time. You want more time on the compliance.
I would like for the compliance review to be done prior to your meet and confer so that you go in with that information. So that you have all of the information that I have during those discussions. I don't want you going into those discussions without all of the resources or tools you might need.
So, Your Honor, you're contemplating that they will provide us with a written report from compliance with regard to the issues that they have?
Absolutely.
All right.
Or I want this case to go just like all the other cases we have. The compliance division review this case, although we've had some procedural issues going forward. I still need an extraordinary tool and resource that I have to rely on, and it's important that they do the review in this case.
The only other thing I was going to mention, Your Honor, was on December 17th of 2018, Judge Otero ordered Ms. Dosch to produce all the statements for the financial accounts for the protected person's guardianship to document the payments being held in a joint locked account, and that she was to preserve all receipts for expenditures from the protected person. And so while the prior accounting that was filed by her prior law firm has some receipts, has 8 months of Amex statements, the November 16th accounting.
This one we have no Amex statements.
No Amex statements. So I'd like you to reaffirm to Ms. Dosch, I've made a written request for the statement, but I'd like you to reaffirm to Ms. Dosch that we should be able to see the statements. At a minimum, I'd like to see the year-end statements. which are readily available to anybody who has a credit card. So, and they should be available now. It's
Would you like those before the 28th, before your meeting?
for the 28th, I think would be helpful to all of us.
Council.
Thank you, Your Honor.
Well, hold on, let me see what Mr. Berchtold has to say about all of those things, and if he agrees, and then I'll get to you.
I think it's great that we're all trying to work together on the same page. We were speaking in the hall, and Mr. Hughes is already saying he understands that he's got to produce the Amex statements. I'm just wondering, but he's also, Ms. Dosch has already pointed out an error in the accounting, and I think Mr. Hughes intends to amend it again. So I'm wondering whether you want to delay the review until we meet and there's an amended accounting. If you want the review up front, that's fine too, but I think it all sounds good.
What's the nature of the error? Is it a dollar math error? Then we're gonna have the accounting now. If it's a major omission or error, then we'll wait for the amended.
She explains to me that I have listed Social Security disability, that he receives that kind of an income. Evidently, that is not correct. He does not receive Social Security disability. So I'm sitting down with her today to figure out what it is that I have listed as income and what it is. I think it's more of a supplement than a.
That's a big difference.
Yeah, I may have just called it the wrong thing. And so she and I are meeting for a few hours this afternoon. But nonetheless, she also has to give me the statements and the receipts that we were talking about. They have made that request. I intend to comply with that request. So I'm just going to pull all that stuff together and get it. At this point, the accounting is submitted. If there are errors or corrections, I will do whatever I can to get those.
You have a continuing duty to amend it as those become apparent to you, counsel.
Your Honor, it's always been one of the issues that we've had, both Ms. Brickfield and myself, is the lack of governmental monies being received, that he hasn't been qualified for disability. These things haven't been done for many ever years. And so I mean, that was one of the concerns of looking at the accounting. So we knew that was out there as an issue, that was incorrect.
We've discussed it previously.
Yes, we have. It's been an issue for us, and the need for additional planning as a result of that.
All right, so what we will do is that we will come back for the accounting. I appreciate that you have a meet and confer scheduled for the 28th. I will request that my counsel, how long do you think you need to file that amended when we reference this income? We change this income? 2 weeks?
I will correct it as quick as I can.
I know, but I know you will, but what timeline do you anticipate? A week or
If it's a
two?
simple error and I just called it the wrong thing, I can do that within a week.
Sure.
That's not a difficult thing. It's understanding what it is that I've screwed up is that's the issue. I submitted this without giving it back to Ms.
So-
Dosch to confirm.
I anticipate 2 weeks for you filing that amended.
Okay.
Understanding that at this point we are over 200 pages, they are starting their review, but their review does take a lot of time and human attention. So you have your meet and confer on the 28th. I will meet with you and see you the week after January 28th on the accounting. If that timeline makes sense to council, and that can help you. So let me give you that date.
February 6th, excuse me, 9:30 a.m.
Council, you will get at a minimum, I think Ms. Brickfield is generous when she understands or sees Judge Ochoa's order, and if you have a problem with the 28th, let me finish this sentence.
I promise the 6th.
Okay, they need to get all receipts. The Amex statement is certainly like a summary and not receipts, but we'll take it. At a minimum, it should be given to you. At a minimum, the year-end statement should be produced. And the order was all receipts. The Amex statement is not receipts. So although I'm ordering that the Amex statements be turned over, especially the end of the year statement, which is readily available, easy to obtain, in the next 2 weeks, I don't want you to take this order as compliance, that the Amex statements comply with his specific order in this case. All right, counsel, you had a problem with that date, is that right?
I do, I have another meeting.
Okay.
I could do the afternoon.
Okay, how about the 5th in the afternoon? Does that work for council?
That's fine.
All right, the 5th.
September, excuse me, February 5th, 1:30 p.m.
All right, now as to the other issues, I have a budget, an amended inventory and record of value, and a planner here. I'll leave the planning here for the end. Let's take the inventory and the monthly budget, council. Get an opportunity to review those. Any concerns? Mr. Berchtold?
No, Your Honor, I have no concerns on the inventory. There were some discrepancy between the inventories filed early on in this case and this inventory. But frankly, the assets that we're talking about are so old that the value is de minimis at best. And Mr. Hughes provides an
Specifically, what are you talking about? Which assets that?
If you look at the footnote, there was, Mr. Hughes points out that there was a 1997 van, I believe.
Okay, the vehicles, okay.
Yes, and the mobile home itself, I tried to get a value online just so you can see how much it's worth, and I couldn't even find a value because it's so old.
And for the record, the Guardian previously listed, and this isn't a footnote in your amended inventory, and a couple of vehicles, a 1993 truck, 1977 Dodge conversion van, and a 1977 mobile home. Council says that the assets are so old that their value is just de minimis.
Mr. Hughes provides titles to all of those to indicate that they are in Ms. Dosch's name, but even the discrepancy between the old and the new is absolutely not worth fighting for because the value is so tiny.
Okay, council, do you have any concerns with the inventory and those, specifically those three vehicles?
So, Your Honor, I have some concerns that, the 41 years of payment, so how many years of payment we have, we just have 3 financial assets, although we have charges all over the accounting for a shed, I don't remember the shed being listed there. And I'm not sure how we explain the differences between the earlier inventories and the later inventories, and frankly, I thought that was going to be part of this new inventory.
Okay.
So I still have some questions about how we get to these inventories here. I specifically have a question about a 2015 van or truck, whatever it is, and I don't know what the financing was for the purchase of that vehicle. I heard Ms. Dosch talking for years about how she doesn't have a source of income other than through Garrett or a limited social security, so I'm not sure where this truck came from. And I think we need to have some discussions about that.
Okay. Council?
I believe that with regards to the inventory, it would probably be better to hold up on that with the accounting and have us discuss it, because there's a number of issues, assets that were awarded to her through a divorce many years ago, items that Garrett's probably paid for. These are all things that we would flush out with regards to the source of payments.
Can you tell me what you mean? So can you give me just a little bit more insight?
So there's a lot of assets that are on and off inventories, and one of the issues that comes up now.
Vehicles, or, I mean,
The real property?
The real
Okay.
property, the vehicle, the 2000, the newer van, we believe that van is probably Garrett's van, or it should be titled to, should be Garrett's van, or how are those payments
so you
made?
believe that
There was no approval from the court, as far as I know, with regard to purchasing a vehicle.
Okay.
These are all things that, in the ordinary course of the guardianship, should have occurred. It's not just that a guardian gets to spend funds that belong to a protected person without the standard. They have to come and ask where these are done. And so I think that we have to come back and look at, when we get the information, have us meet and confer to go through these items and determine whether the source of the purchase of the items was Garrett's money or not. Some of these assets are, some of the assets are definitely hers, because they're quite old, or was awarded to her in a divorce. But many of the assets are going to be, or should be Garrett's assets. And there's issues with regard to items that still appear with regard to payments on loans that are in this accounting, the source, and so what's the asset that's the underlying asset, or is it a situation where this loan is, as she has previously stated with regard to at least one loan, that it was a result of my client breaking his arm, I believe, back when he was about 12 years old? Well, that clearly shouldn't be something that's being paid for by Garrett. And certainly, if you have a 12-year-old child, that's something a parent has an obligation to provide, for the child. And I don't have a really good understanding of how all these finances have come into play. I think that those are all important things. There's many issues that arise within the inventory and the accounting that are problematic. And hopefully we can resolve these by sitting down, but again, we did just get this last week. It's hundreds of pages and it doesn't have the detail or the information that should have been included, especially in light of the fact of Judge Ochoa's order from over a year ago.
Council, do you have, hearing their concerns about the inventory and the overlap between the inventory and the accounting, does it make sense to allow you to talk about this in a meeting and confer and then get back to me the week after?
I think it's a good idea to try to answer any questions that there are, to try to meet and talk about them and avoid additional expenses and expenditures of time.
And Council, I agree with you about a conversion ban that is from 1977, that if, and I don't know what the value of it might be, if it is so de minimis, I don't expect, and Council, I think you know this, I don't expect you to spend all of your time and energy discussing a vehicle that's worth $200 or has no worth, okay? However, it does raise some concerns, and I can understand their concerns about real property or payments of loans, or what seems to be the conflation of accounts or accounting, perhaps. All right, so we'll set that aside. As for the monthly budget, everybody was okay with that?
No.
No, oh, I'm
Your
sorry.
Honor, nobody's okay with anything.
Oh, okay.
That's kind of the history of
You
this
were
case.
you looked so happy though. Okay,
No,
Ms. Brickfield, go ahead. The
It's,
budget.
it's a concern, and again, I think that's part of what we believed was gonna be part of the meeting conferred,
Okay.
that.
But I wanna hear, I need to set you on the right track for this meet and confer, and I wanna
Right.
hear what your concerns are now.
So,
Cause I need to keep your feet to the fire on this case, everyone's, all right?
which is where we wanna be, but it's remarkable that the budget somehow matches the monthly income, and we don't have any justifications for some of the amounts that were in this proposed budget, whether it was in 2018 or now when it's filed again. And for example, so somehow we have $1,300 worth of room and board, but I don't know how we get to that number for rent,
Okay.
for room and board. I don't see what this loan is that Garrett's supposed to be paying. I don't see a plan for the tutoring, and I noticed that the people for whom payments have been made and attributed as tutoring, and the person who is now going to be doing the tutoring aren't one and the same. We have 3 or 4 people in the last payout, we have 1 person now. There's a thing about supplements, we need to have a discussion about whether or not Garrett should be paying so much for medical insurance. All of that
That was
needs to
my
be worked
question.
out. Sorry,
Okay, medical insurance.
medical
Medical insurance.
insurance, but if he was in a special
Right.
needs trust, he wouldn't have any payments.
Right, that was my concern. All right, so you will address those at, your meet and confer.
Okay.
Special needs trust, eligibility for,
Medicaid.
how do we come up with, my notes are the room and board, those things, laundry service, these things.
Right.
I need, more information, I think more information is appropriate. Okay, that takes care of the financial issues, which really you're going to talk about on the 28th. I hope you set aside a good part of your calendar, council, on the 28th to discuss all these things. So the plan of care. You know that I was very interested in this. You knew that I was looking for. And the questions and concerns that I had. Council. About the plan of care, do you have any concerns?
Your Honor, the plan of care is fully, I mean, it's really just maintaining the status quo for what Garrett has had, and that's absolutely inappropriate. He needs to have so much more care. We have Dr. Brown's report, we have Dr. Commissar, numerous reports, and how the therapist would determine that he wouldn't benefit from having occupational therapy is just absolutely blows my mind. I think that's so strange.
Yep.
I mean, and that they discharged him with a home exercise program. I don't believe that he can implement his own home exercise program appropriately. And it's not even necessarily exercise. He needs to be able to learn to better communicate. Years ago, he was able to do sign language. He was able to communicate at a much higher level than he is now. These things need to be evaluated. Dr. Kinosara's report confirms that he needs to have occupational therapy and needs to learn how to use devices to help him communicate. That's wholly lacking in this plan, and I would almost call the care plan is the non-care plan. It's really sad that it's a situation where they're just merely investigating communication devices, and they haven't gone forward, and the occupational therapist or the therapist in networks didn't have any suggestions of what they could do. The Guardian provides a resume for Dr. Reiner and merely alleges that he received regular annual visits with him, but provides no documentation or records or any recommendations from Dr. Reimer. I don't think that the issue is what his blood pressure level is or what his basic health needs are, is how can his life be better? How can he learn to communicate? What's his plan for the future? He has to learn to work with others, not solely his mother. And there has to be a mechanism for him to communicate. If she suffers a heart attack in the home, how is he going to call for help? What's the plan? No plans are just not appropriate. What if something happens to both of them? How is he going to be able to communicate to get help? And I don't believe that any of the suggestions fall within the purview of what was contemplated as a care plan for Garrett. And realistically, everyone here wants Garrett to live the best life that Garrett can. And despite the fact that the Guardian wants to make personal attacks on myself and my clients, everybody wants what Garrett wants and needs, to be able to communicate, to be able to live a good life. And that's what's important for everyone here. And I do want to point out that she's raised issues with regard to, in her recent filing, that Mr. Gottesman was someone of my choosing, and she has concerns about our request of special needs trust be developed for him. I've never even met Mr. Gottesman. Mr. Gottesman is not someone I recommended. That trust that was done for him is a prior estate plan. That's all when neither my client nor myself were being noticed in this case. For many years, back when the guardianship records weren't accessible online, and you had to come to the courthouse, we had a request for special notice, and we weren't provided notice for years of things that were going on in this case. It's a situation where she's also made allegations that I kidnapped her son Travis, my client. I mean, if you want to ever ask him questions whether I kidnapped him.
You kidnapped him?
Yes, that I kidnapped him. She puts that in the record to Dr. Brown. That's a representation, it's in public record here, that I kidnapped my client Travis years ago when I was successful, along with an attorney in our office, Ms. Shelley Crone, in getting that guardianship terminated. Also alleges that in kidnapping him, I utilized the procurement of sexual promises, I guess is the word I would use, or something of that nature, from Shelley Crone to do that, to remove him from his mother, which is the furthest thing from the truth. We are simply his attorneys. She's alleged that, we're causing, all these costs in this case. I'll submit to you, Ms. Brickfield and I are working here for $100 an hour, and my clients are paying me. My clients have not ever requested that Garrett's money rather be used. Travis and Melodie have paid all my fees. She also, years ago, alleged that I stole his settlement. So and she reiterates these things when she goes to the doctors, when she's gone to Dr. Kinosara and when she went to Dr. Brown. And when my clients did get the one-time visitation that was at the library, all she did the whole time was talk about how terrible I am that I've done these things. And Garrett and Melodie are like, we're here to talk to, Travis and Melodie we're here to talk to Garrett. So I think that there's some level of delusion that she has, that these things keep coming up. And I think that this needs to be stopped. And, if you read Dr. Brown's report, you read Dr. Kinosara's report, these are all issues that are raised. And Dr. Brown went so far to ask, he said, kidnapped, you're saying Ms. Goldsmith kidnapped Travis? Do you mean figuratively or actually? And she said, actually. So I think that until she understands that this court has authority over this case to get this information, and that these things are falsehoods, she really is creating these red herrings in her filings. And they continue. They've been present with many lawyers in this case, that this is the information she provides to them. And my clients can set that record straight. We just need to get her on task.
Counsel, what's and I'll hear you each on your objections or concerns, but in conjunction with your objection or concerns, counsel, what is your suggestion on moving forward regarding the plan of care?
I believe that Garrett needs to be evaluated by an appropriate occupational therapist, probably in Clark County. So we need to agree to an occupational therapist that can do an appropriate evaluation and plan of care. Because what we have is absolutely lacking.
So it's an assessment of neurocognition by Kinosara, date of examination March 11, 2019, but it is not a neuropsychological evaluation. I was surprised about the occupational therapy recommendation. I'm not sure that an occupational therapist is the level of evaluation that he needs for a care plan, but I will hear counsel. Ms. Berchtold, anything you want to add to that?
So, Dr. Brown, Your Honor, in his report, and I think you read his report, pointed out there were two ways to go for Garrett, but he also said that he thought that he was recommending something like an assessment and observation by Opportunity Village. He recommended a completion of a vocational rehabilitation assessment. At a minimum, we need an assessment by an occupational therapist who is looking to work with Garrett for his communication skills.
Is that the person, and I'm asking, is that the person that's best suited to deal with those communication issues? Or is there, is that a subspecialty of occupational therapists, or is there someone else who is better suited to deal with? I don't know, that's my question.
And I don't know that either, Your Honor. I was going to ask if we would be authorized to take back the proposed plan of care back to Dr. Kinosara and Dr. Brown and see what they think. We've paid them both they met with Garrett, they met with Mrs. Dosch. Dr. Brown met with both of you.
Yes, ma'am.
So they could take a look at that plan and give us all their thoughts on the best way to proceed with this at this time. I'm concerned that we have somebody here who's supposedly gonna tutor Garrett on a communication device. We don't even know, she seems to have an excellent background as a teacher, but she's not a trained occupational therapist. Don't even know what device she would be talking about, and I don't think she knows that. I agree with you, there are people in the field, we just need to find them.
Mr. Berchtold.
So here's my concern with the never-ending evaluations.
An absolute decree of divorce is granted.
By September 6th, you will pay $6,000 of what is due.
Best interest is not, can you give her a pony?
I'm gonna ask the question to make sure we're being accurate with what the doctor states.
To find out what the facts were. I agree, the record's a mess.
I make a finding that paternity has been established.
He was a potential future to his children.
Here's my concern with the never-ending evaluations. We had them evaluated by Consort. I said, that's a very thorough report, and why are we spending money on an additional report? And they said, no, it's gotta be done. And so now we have a report from Dr. Brown. And everybody assured me that that would be the last report, because each of these reports Garrett is paying for. And now it's an occupational therapist or a vocational therapist. Garrett is 41. He will not be entering the work field. I have reached out to DRC to see if there's a speech therapist that we could talk to who potentially could give us some instruction. I don't think that having Dr. Brown and Dr. Consor review the plan of care is a bad idea. I just want this to end at some point so that Garrett can live his life. The thing that I took from Consor's report and Brown's report is that Garrett is very happy and very content and in an environment where he is perfectly happy and where he is, and where that environment matches his skill levels and his abilities. And so I'm not really sure what everyone is looking for here. Yes, it would be great if Garrett had more communication abilities. Is an occupational therapist or a vocational therapist the person to get that? I don't think so.
That was my question to council in general. My concern has been in this case, the allegation and the evidence that he was very communicative and able to utilize American Sign Language and communicate and speak. And understanding that his injury his delays come from birth, that he attended public school until he was homeschooled in late high school at his mom's decision making. But after that, he was able to communicate and had a far greater ability to communicate than he does right now. There was something, although his condition or his delays didn't change, it's not as though he had a heart attack or stroke that impacted him at a certain age. This was a developmental delay he was dealing with for his entire life. And he was operating at a much higher level, and now we are not at that level. You would expect to see improvement, even however so slight, or the status quo. What we wouldn't expect to see, and which I think is the court's concern, is at his age, which, is not old at all.
No, it's not.
It's very young,
Yeah.
okay? And he has his entire life ahead of him, okay? He is not even at middle age, right? He is a young man in his prime, that his ability to communicate with others is a tool that I think is so important to him and impacts his entire quality of life and his ability not just to communicate with his mother, who's his caregiver now, but in the unfortunate event that his mom couldn't be his caregiver anymore, or that her ability to care for him was limited somehow by something that happened to her, or circumstances outside of our control, that he would be able to communicate with others. That is my terrific concern in this case. And I understand, and I've read the reports, that he enjoys walking around on that ranch, and that brings him great joy. And his ability, right, Garrett? We're just talking about you. I see you looking at me. I'm talking about you. That I know that you love walking around on that ranch in your neighborhood. See, it makes him happy just thinking about it, okay? And that's a big deal to him. And the doctors have mentioned that many times, all right? And we want to make sure that he can do that, okay? But he is also a vulnerable person, all right? Because of his disabilities and his special abilities, but also because he has lost somehow this ability to communicate. And I say that it's a concern to me. And I would expect him to stay the same or improve slightly, but not for this ability to totally vanish and go away. I feel like, and I understand that your concerns that you don't want any more cost to Garrett, and I don't either. But how much do we put a price on the value of the ability for a protected person to communicate? I hate to say $100 is it, or $5,000 are it, because I'll tell you, if I lost the ability to communicate, well, us lawyers are sure different than a lot of other people. We like to talk, don't we? So if we lost the ability to communicate, I might say that's worth millions and millions of dollars to me. So I'm worried about it, Mr. Berchtold. I'm worried, and we take this and we lay it upon these allegations of financial misconduct and this extraordinary amount of questions, and we know for sure we're not complying with the orders from Judge Ochoa from a year ago. All of it kind of stacks up on itself. I need more eyes. I need more professionals. I have questions about who is best to help him with communication, okay? If it costs us an extra hearing, that's what it costs us. If it costs us somebody else reviewing it, that's what we're doing, okay? So Mr. Hughes, I'll hear from you as to whether or not you would like Dr. Consorza and Brown to review the plan of care. If you have any objections to that, to see what their additions or concerns or professional view might be.
Your Honor,
And you may have no position.
I do.
Okay.
This whole thing is very frustrating. I mean, when I look at the accounting and we list out the money, we can see that she's not going on cruises, and yet she's being accused of stealing all this money. We know that prior, Joshua Gottesman took large chunks of money, but somehow that seems to be overlooked and my client's at fault. So, I mean, there's no big, I review this accounting and I don't see problems. I know there are holes in it. We don't have receipts, we don't have little details, but there's not big chunks of money that are missing. Matter of fact, I looked at the accounting from prior and you know, I want to say about 2003, this had $80,000 in this estate, and we're up to $350,000. Now, I know he's getting payments and things, but this is increasing. It's not seem to be diminishing even after Joshua Gottesman stole money out of the estate. However, he is a young man, and this money has to
Thank you for saying he's a young man.
This has to reside.
It has to take care of him for a
life.
long time.
And we are nitpicking this to death about, let's get this thing fixed, let's get him checked here, let's go there, let's do this. And now we're going back to the same doctors to have something else reviewed. And when I submit something else, we're gonna have that reviewed. It seems to be a never-ending thing of let's fix him. Whereas Dr. Brown said, I'm not sure it can be fixed. That was Dr. Brown's statement. I don't think there's much we can do to improve. And he said it could be wishful thinking.
And I need somebody to tell me why he was communicating and speaking at this level and now does not. So let me, no. Look, I agree. We absolutely are nitpicking. You know why? Because that's what the statute says I gotta do.
Right.
That statute says, and Judge Ochoa's order is every receipt. So if that's nitpicky, guardianship ain't easy, friend, and you know it. So listen, so that means you have to keep every receipt. Well, I'll see them, okay? I know it's tough. Council, I've already said to you, I'm not interested in the de minimis or small value of a 1977 conversion van, all right? What I am interested in is there's allegations that he's paying loans for a 12-year-old broken arm.
No, I understand that.
I know she's not going on a cruise, but what I told you is I think this is a conflation of assets, right? Absolutely, totally against the rules. I don't write the rules. Nobody asked me, okay? I'm here to enforce them, and that's what we're doing. I understand that you think they're nitpicky. Nobody's saying she did it on purpose, or she has malintent, or she's trying to steal $5 so she can do something else. No, we gotta get this in order. It has to be right. And I'm not saying that, and I don't want you to label this as I'm trying to fix him, okay? Garrett is perfect, just the way he is. I'm not trying to fix anything. However, do I want for him the very best in his life? Absolutely, okay? If that means another specialist to make sure that he can communicate to the best of his ability, that is what we are doing, all right? But I don't want, I want to correct that word in the record, that is not my intention, that he doesn't need fixing. He is 100% perfect. The end. What he does need is the resources and opportunities to live his best life. And I will make sure that he's got them.
Well, I guess because I see a way to address the other items. We're having a meeting, we're gonna address those things somehow. I hope we can come to some agreement on how to fix that stuff. But when we're talking about further going on with having other medical things looking at, $5,000 at a time for each of these doctors.
They're asking for the doctors to review this paperwork, not see Garrett again.
Well, and then they're going to suggest what's the path. And if we're talking about his communication skills and we're limiting it to that, I see a way that I can be a lot more relieved. But we seem to keep going to this therapy and that therapy and this neurologist, and it just seems to explode exponentially, mushrooms. And I want to get
I understand. So hold on, let me just say this. I understand it now. There is not a one-stop shop. There's not one doctor in town that you can go to get all of your special needs dealt with at one time. Because you know what? If there was, every mother would be fighting, tooth and nail to get in that line, all right? So let me tell you that in dealing with special needs and extraordinary people, you're just gonna go to a lot of doctors. And I'm sorry that I can't make that list smaller. And I'm sorry that he's a special kind of guy, because he's super special to me, that he needs more than one doctor. But I need the best for him, okay? And I know that it seems overwhelming, and nobody wants to go to all these doctors' visits, but what I'm seeing is that we're only going to the dentist once a year. I don't have the reports. What I'm seeing is that it's going to annually for a visit to the doctor, but I don't have any reports. So I'm just confused, all right? I need more. And I've been very transparent. And Mr. Hughes, I'm giving it to you, but I know that you're late to the game, okay? And that you have not been the attorney of record for the Guardian in this case for really an extraordinary amount of time, just a few months. I have tried to be, and I know that I'm the new judge. I know that this was a case that Judge Ochoa dealt with for years. I try to be very transparent about what I'm concerned about, okay? I'll tell you, okay? The reason why I tell you instead of not saying anything is so that you can go find out more information from me and meet and confer and discuss that issue. It's not to read you the right egg or give you a hard time. It's because I really want you to know what I'm thinking, okay? So that we can save the Guardian and the state and council and pro bono council and everybody else a whole bunch of money coming back to these hearings, because you'll know what I'm concerned about, okay? I say those things because I'm concerned and I want to know more, all right? Mr. Hughes, it sounds like all of the issues, that there's no resolution on any of the issues. I'm going to order that Doctors Candace, Sara, and Britt be allowed to review the plan of care for the protected person. I will tell you, counsel, given the uniqueness of Garrett, that there is not a golden ticket. There's not a right answer to the plan of care, okay? I think this is a medical art form, that we've imposed our legal rules on top of, that many reasonable doctors could disagree. Many reasonable legal professionals could disagree. But I think we can get more information, and that we can have a plan. This plan is, it tells me what's going on right now. It doesn't really give me a map, a plan forward. The plan should be, he will see his physician 1 time per year minimum for a well check, in addition to any sick visits. He should see his dental provider twice a year for cleanings. He will see, this, if it's a tutor that you're proposing, that he will see this tutor whose resume is attached twice a week to learn about such and such method of communication. And this is some more information about that method. It needs to be a plan. This is a review. I appreciate Mr. Berchtold reaching out to DRC and Opportunity Village for additional referrals, because they might be the source of those referrals.
That's what I assume they are. They do this all the time. So I will reach out to them again and try to get some help.
All right, and I continue to be concerned about that interaction and that social interaction and vocational interaction that he might need. And perhaps even though he is far away in the farthest away from me in Clark County, I guess, that there may be positions or vocational things that are available there that DRC can support. That, that's their job. So they may have to be creative, or they can come and see me.
I'll see if I can find out.
All right.
See if I can find out.
Council, anything else?
A couple things, Your Honor. As part of the plan, part of this care plan, I think it's important to note that, like you said, he's a young man, he's 41 years of age.
I love it when you say that.
It's very young. Part of the reason that Mr. Hughes points out that now there's more money, it's because there's large payments that come every 5 years, and there's only $650,000 left that's going to be distributed.
Paid out.
Mm-hmm. And so that's concerning. So what's the plan for that? How is that going to provide for everything he needs in the future? And I think part of the plan should include the implementation of a special needs trust, because if he has a special needs trust, then a lot of this arguing back and forth with regard to medical expenses, he would then be on Medicaid. And whatever money is left over in a special needs trust, when he passes, would go back to pay the state back any monies that they're owed. Generally speaking, in a situation like this, the state's going to get back pennies on the dollar, 20 cents on the dollar, because he's going to have a lot of needs and a lot of things that are being picked up through Medicaid. And that's something that just has to be done in this case. And if it's done sooner rather than later, wonderful. We've been asking for that for years.
We've been talking about the absence
and
of the special needs trust for some time. I want you to discuss it on the 28th.
And it's something that was brought up with Judge Potter, who had the case, but then it was transferred to Judge Ochoa because of the Barneys. The Barneys were involved in, they were former counsel. And I think Mr. Hughes is counsel 13 for in the case, something like that. So we've had the door just keeps turning over the years of her counsel. We're hopeful Mr. Hughes will be around for a while with the case. And to point out a few other issues, if these debts that are on here are related to debts she incurred many years ago, I'm not sure why she hasn't filed for Chapter 7 bankruptcy protection to wipe these out rather than using her son's money to pay these obligations. Clearly, the assets that she probably has would be within the exemptions, and she would probably be able to retain those assets because, but someone would have to do that evaluation. These are all things that should be explored. They're things that we can discuss at the conference and meet and confirm. And the only other thing I want to bring up, just because you do have jurisdiction over Ms. Dosch, because she's the guardian, that she has a tendency to send these packets out that have this information about me, about my clients. And my clients are employed people, my clients are
Send it out.
She has these packets. The information that she provides with regard to she provides information, say to Dr. Kinosara, she provides this packet of it's about 70 pages, and she provided it to the court, and it makes allegations against both my clients as well as myself and Shelley Crone. And I really think that she needs to understand that that's just not appropriate behavior to be happening. And that she's doing it under the guise of this case. So I think that you do have jurisdiction to have a discussion with her about that.
I'm gonna ask Mr. Hughes to have that discussion with his client.
Thank you.
Mr. Brickfield, anything else?
Not much today, thank you.
Counsel, anything else?
There was an issue that Mr. Hughes and I wanted to discuss with you. For some reason, you may have noticed that Ms. Dosch uses essentially as an operating account, a bank account that's at America First.
Yes.
And for some reason, the bank has told her that account is now blocked and they won't let her utilize it. And we're not really sure why, and they won't tell anybody why they've done it, and they've sort of done it kind of sua sponte on their own accord. So we were wondering if we could submit an order getting access to that account, because we're not sure what's going on.
What account is that?
It's the
account, the blocked account pays into.
This one, where she puts the monthly deposit?
The America First account?
Yes.
Yes.
They, in the middle of December, they just stopped, they just said it's blocked, and it was as a result of some law firm in Las Vegas is what she was told. We don't know what that means, whether it's work that we did that somehow triggered them to just block it, because he issued subpoenas or whatever. We don't care, we just want to get an order that says that's the operating account, she's allowed to use it.
So I'm afraid that I somehow triggered it by asking for the bank records. I'm not really sure exactly what happened. I'd be happy to call them and see if I can clear it up, but if we can't clear it up, would we be able to submit an order to you?
Counsel, this is the smallest, well, not the smallest, but there are 2 Wells Fargo bank accounts. One of those has a large value, but it looks like there's an America First account with several $1,000s that she's utilizing as her kind of operating account to pay those monthly expenses. Do you have any, first of all, I don't know that America First will even respond to a court order from me on blocking the order.
Sure.
But, counsel, do you have any objections to their request?
So right now, the order that's in place says that $4,000 a month is what's available for Garrett's care. And it's supposed to be moved from, I guess, the Wells Fargo account into this account. And so to the extent that funds come out, they should be limited to that $4,000 a month that goes in. And so that is my only concern. I think it should be unblocked to the extent of $4,000 a month and not more than that.
And we're not talking about the actual block account. The block account will stay blocked,
Right.
and the $4,000 release will continue to
Right.
come. This is,
I understand that, but what I'm saying is to the extent that more than $4,000 goes out of that, or things are deposited into that account, that shouldn't necessarily, so any deposit that comes in for Garrett should go into the Wells Fargo account and be frozen, right? Or be blocked, and then $4,000 moves a month. My concern is to make sure that there are not gonna be additional deposits now going into this
Counsel,
now
are there
unlocked
additional
account.
deposits other than the court-ordered $4,000 amount that comes monthly from the Wells Fargo account to the First America account? Is there additional deposits other than that $4,000 that goes into the First America account?
Not that I know of, Your Honor. And I don't
It's certainly
want-
not Social Security.
No, and I don't want to put a limit on her operating account. We don't need 2 blocked accounts. I think,
No, I don't want a blocked account, but I think what council's concern is that $4,000 is coming out every month. And I'm seeing right now, there's 6,000 and change in there, and it's building up, and we're not spending it on Garrett, and then we're.
So on,
okay,
it looks like on 3/20/29 of 2018, a deposit was made into that account of $1,009.12. So we're not sure where that money came from, but if it's put
That's
in,
not the 4,000.
that was prior to that
That was
order, I
it.
believe.
other than the 4,000. So that should have gone into the Wells Fargo account. So that's
so
part of what's driving my
let
concern.
me do this. I will just make a call and see if I can figure out how to unblock the account.
But the issues still remain.
Well, March 2018 is, I believe, before that temporary order, so I'm not exactly sure. I mean, the $4,000 temporary order was after that, you know,
See if Mr. Berchtold can speak to the bank,
okay.
okay? If, the bank, there's a couple things that concern me. Sometimes a bank can freeze an account just by virtue of us having these hearings And I don't know how they find out, but they find out and they stop. Or contact by Adult Protective Services or someone else will trigger the bank to freeze the account. It's by no court order or no action of the parties. What happens internally at each bank is different. And the reason why they freeze accounts, I don't necessarily control, nor do I have the power over. However, I will clarify the order that the Wells Fargo account is the blocked account. That this America First is being utilized as her operating account, and there is no court order freezing it or blocking it. And so I will issue that order. And I would sign that order specifically directed to America First if it would help counsel.
All right, well, let me find out. Thank you.
All right.
And that would come from him?
Or
Garrett's
Mr.
counsel?
Hughes,
Okay.
that's fine.
Okay.
Counsel, anything else for today?
No.
All
No,
right.
Your Honor.
Thank you so much. Thank you for your hard work.
Thank you.
Oh, Garrett, thanks for coming to see me, buddy. I appreciate you. Good to see ya. Joe is next.
Page 15, Hamilton.